Good afternoon, everyone. Hopefully you can hear me clearly. If there's any problems or anything, please just drop some comments into the questions box. Welcome to our third in our series of health and safety updates. As those of you that have attended the previous ones will be aware, the aim of this is to look at a ongoing case study that the health and safety team here have put together, with this culminating in a mock trial 5th of October this year, which we'll hold here at Phil Fisher in London, which will be a face-to-face event and promises to be a really good event, and there'll be more information coming out to everyone over the next few days and weeks for that. But today, we're going to look at the role of the health and safety executive, and when I say the HSE, you can apply that to local authorities who have investigating powers as well in these types of incidents. Hopefully most of you know who I am. So my name is Andrew Sanson. I'm a partner in the dispute resolution team here at Phil Fisher and head up the health and safety team. Number of years experience in terms of looking after clients in the health and safety world, both proactively in terms of making sure they're compliant and also reactively when something goes wrong and they need us to come and look after them. I'm joined by Elliot Kenton, who some of you will remember was a senior associate with us. He then decided to leave and has now come back. So it's good to have Elliot back with us.
Thank you very much, Andrew.
I won't make any jokes about Elliot leaving and coming back, but it is good to have him back with us. And also, I'd like to say the other members of the health and safety team who have contributed in terms of the slides for today, specifically Kirsty Inver, who's put the slides together. She can't join us today, but in terms of the presentation, but big thanks to Kirsty in terms of pulling all of this together. As I said, this is the third in a series of our health and safety roundtables. The role of the HSE, we will take a bit of a break for the summer period because just in terms of people's holidays and availability. And then on the 5th of September, we'll have our final roundtable, which will be preparing for trial, with the mock trial held on the 5th of October, like I said, which will be here. It'll be very much interactive. The more of you that can can come along will be great. There'll be a networking opportunity and drinks and that sort of thing as well. So pencil that in, and like I said, there'll be more information coming out. So as I said, purpose of today is to look at the role of the HSE, what they do, what they can't do, how we interact with them, and the types of sort of practical advice that we give clients in terms of dealing with the HSE. So starting off, in terms of the powers that the HSE have, I think this is a useful starting point because having a good relationship with a regulator like the HSE is important, but also knowing what the limitations are in terms of that relationship, what they can and can't do, and what you are obliged to do if there is an incident. So, as I'm sure most of you are aware, HSE will come in and investigate workplace incidents, whether it's been injury, accidents, near misses. But they will come in and start an investigation. And they have pretty extensive powers within the health and safety world in terms of monitoring, in terms of investigating, in terms of coming in, speaking to organisations and looking at what's been going on or what potentially could have gone on. The rights of inspectors, they do have the power to enter the business premises to start an investigation, and there are times when they arrived unannounced. What I often hear from clients who are, often the first point of contact with a HSE inspector are that most of the time the HSE will sort of phone up and say, look, we want to come in and have a look. We want to make sure the right people are on site. we want to make sure we're talking to the right people within the business, and therefore, sort of diarise that appointment. But it's also worth noting they can turn up unannounced. They do turn up unannounced. I suppose the one thing I would flag in terms of that is making sure within the organisation that there is a protocol and a policy in place with regards to unannounced visits by HSE or any other regulator, actually, so that if somebody turns up, the business knows what to do. It's not left to somebody who's not in a position to deal with questions to look after that inspector, but it's escalated quickly within the business. The right person is there to deal with it and knows how to respond in terms of providing information or not providing information. So in terms of what the organisations are at risk at, where there is a HSE investigation and possibly a prosecution, regulatory action being taken. As I mentioned, there's the possibility of a prosecution and associated financial penalties with that. That's always the headline, really. When you see health and safety updates from the HSE, they often publish recent prosecutions, and the headlines are generally what offence has been committed, the company, how much the company's been fined, and costs. And absolutely right, it gives organisations an idea of where HSE is going in terms of enforcement. I think more importantly, though, and what is often forgotten, is the serious reputational damage that comes with that. The fines are published, they're part of public record, and for organisations that have contracts, maybe in the public sector, one of the first questions that's often asked is, have you as an organisation been convicted of health and safety offence in the last 12 months, in the last 2 years? And if you're answering yes to that, a lot of the time that's the end of the procurement process, the tender process, and organisations can lose contracts because they've been prosecuted, and that has a much bigger penalty sometimes than the actual fine themselves. And that's something that often gets forgotten about, I think. And also, I think one of the things I would say is, and I often hear this from clients who've gone through the process of dealing with a prosecution or an investigation, that the actual process of the investigation and prosecution, the number of lost working days, the number of lost management days that are taken up dealing with this process it's phenomenal. And if you put a cost on that, again, there are times when that actually outstrips the fine itself, and they're always worth keeping those into considerations. And I think importantly, in terms of the impact on the business, on the employees, on morale within the business. So having people coming in and investigating, there's the financial impact in terms of the fine, but there's also the ongoing impact. So talking about investigations, when do HSE investigate? I appreciate that sounds fairly simple, but I think it's worth remembering, when can HSE come in, when can they investigate? And I've put sort of 5 bullet points up there, most of which I hope are not new to anyone listening. I hope are pretty clear. Obviously, fatality at work. You have the issue of potentially police being involved initially, and then under the memorandum of understanding they've got with the HSE, hopefully that being pushed across to HSE as soon as possible for them to investigate. We often get involved in that stage, and we're often pushing for HSE involvement as soon as possible, because they have the right tools and the right knowledge and the right expertise in terms of dealing with that. Work-related accidents, in terms of very serious ones, multiple fractures, loss of sight, etc., etc. Again, sometimes the police may be first on the scene, but hopefully it's passed over to the HSE or local authority as soon as possible. Occupational disease, again under Riddle, this is more of an ongoing process due to the nature of the incident. And also the catch-all, I suppose, is instance that where there's a likelihood of serious breach of the regulations, the legislation, and major hazard issues. You know, these are, I suppose, the near misses would fit into this. You know, the real potentials, or where there's been an incident, but it could have been much more serious. So these are, generally speaking, where the HSE will get involved. What I should say is, and this probably won't come as much of a surprise, like most organisations, public sector regulatory organisations at the moment, in terms of their ability to investigate, in terms of the resources they have, they are stretched. They are looking. You know, they don't investigate everything, primarily because they don't have the resources to do it. They don't have the manpower or autonomously the financial resources to do that. They often take an approach of looking at a particular area, a particular sector over a 12-month period, 18-month period, and focus on that. You know, and what that may be, you know, varies from time to time. We do try and sort of keep an eye on where they are looking, and sort of update clients in terms of that. And that's the sort of broad approach in terms of what they can do, what they can't do, what they're looking at. Elliot's going to have a look at the case study now and work our way through that. Like I say, it's the case study we've been focusing on over the last few months, and more importantly, what we'll be looking at in terms of the mock trial. Elliot.
Thanks very much, Andrew. So, as Andrew said, we have a case study that pretty much permeates throughout the whole of the Roundtable series. And this will be, the case study will be used during the mock trial in October. So for those who haven't joined us previously, the case study is on the slides, but it's a typical kind of investigation, incident investigation we would usually see in practice. So in this case, we have a construction site, and obviously construction is an area where there is a high risk of injury and death, and then one of the key sectors in the health and safety executives sector focuses. An agency contractor attends the site, is working on a scaffold. He is an agency contractor, which is very is quite prominent in this case study, and his agency does not provide him with a lanyard, as they assumed the site would. So a common misunderstanding on the construction site. The site does not have enough lanyards available to allocate one to the agency contractor. He's incredibly experienced, as we see in practice. Experience doesn't necessarily equate to anything when it comes to workplace injury, and he sets to work without the lanyard to tether him. The unit shifts on the scaffold, and without the lanyard to tether him, he falls 16 feet to the ground. As our viewers can imagine, very serious injuries they're very serious injuries. He's lost consciousness on impact. He suffered fractures to his collarbone and shoulder. Luckily, it is not a fatality, but a serious injuries nevertheless. So how would the HSE inspect this kind of case? So this is a Riddle reportable incident. There's been multiple fractures. It's a serious health and safety incident. And given the seriousness of the injury, we would expect an inspector to come onto site. The HSE will take a methodical approach to an investigation. They will seek to gather information, identify any potential causes to the incident, and determine what action is required to prevent recurrence. The HSE is not just out there to prosecute and enforce. It is a statutory body that tries to prevent incidents happening again. In this case, what we would expect the HSE to do would be to firstly visit the construction site following the Riddle report. They would speak to the relevant people, such as any witnesses to the incident, employees, supervisors, and employee representatives. I think it's also really important to point out, obviously, this is an agency worker, so they'll be speaking to a wider category of individuals than we usually see. They will not only want to look at information specific to the incident, but more general information about what the workers do, what they don't do, and the safety procedures that are followed. They will also observe the site's conditions and existing practices. In this case, quite prominently, they will inspect the equipment, they'll inspect the scaffold and see why it came loose. And they will request to review the documentation and records, the health and safety suite of policies and procedures and risk assessments. And that's why it's also quite critical to have a comprehensive suite of health and safety systems and policies and procedures on hand, in addition to an incident response protocol, so that you are ready if something like this ever occurs. They will also be looking at documentation relating to the agency of the injured person. And they'll also, something that's not mentioned on the slides, but they'll also possibly take photographs of the site. So the key investigative tool that is used by the HSE, which is used by a number of investigatory agencies like the police, like HMRC, and a few others, is the HSE have the power to conduct interviews under caution where a person is suspected of committing a criminal offence. Although there is no express legal requirement that a company or a person suspected of committing a criminal offence is interviewed under caution, they are routinely used as a key investigative tool along with other key investigative tools which are enshrined by the Health and Safety at Work Act. The power for an interview under caution comes from the Police Criminal Evidence Act, so PACE for short. And for this reason, the interviews are referred to as PACE interviews. The purpose of the interviews is for the HSE to gain information to assist with their investigation and to reach a prosecution decision. And they must, at the decision to prosecute, they must have sufficient evidence to provide for a realistic prospect of conviction. And part of that evidence is likely to be the record from the interview under caution. We have the caution on the slide there. I won't repeat it, but that is what has to be said to someone, a suspect, under an interview under caution. So, in HSE interviews under caution, the suspect, usually corporate, will be invited in writing to attend an interview, usually at the HSE's offices. It'll be made clear in the invitation that this is an interview under caution and therefore they have certain statutory rights. If the suspect is a company, the company will be asked to nominate a representative to attend on the company's behalf and speak on behalf of the company. What's commonly not known is that the suspect may decline an invitation under caution. However, in this case, we would strongly encourage a company to seek legal advice on this, because such refusal may be brought to the court's attention in relation to sentencing, which the critical point being here is whether the suspect was cooperative with the HSE's investigation. The interview will be audio recorded, and a transcript can then be used as evidence if the prosecution is later forthcoming. And the final point is very critical. One of the statutory rights that a suspect has for an interview under caution is they have the right to consult privately with a solicitor and for a solicitor to attend the interview. And as we've said on the slide, having a solicitor present really protects the company or the individual to ensure that the interview is conducted properly and the suspect's rights are protected. Where Andrew and I see things go wrong is when a company has gone to an interview under caution without any advice and without legal representation. So it is really critical, if you are invited to an interview under caution, that you seek legal advice from either your own lawyers or hopefully Phil Fisher. I think we are next on to enforcement action.
Yeah, you know, what we're talking through today and this series is, you know, sort of just hopefully coming at it from a more of a commercial approach. Our basis for interaction with regulatory authorities is that we try and approach it in a way whereby we're helping their investigation. The client is helping their investigation. That's not to say it's at the detriment of protecting the clients. That's absolutely the whole point of it. But going back to what Elliot said, if you have a good relationship with the regulator and you are seen to be assisting, then if it does come to a prosecution, often the regulators will take a favourable approach, and it bears dividends at that point. I think I said in one of our earlier roundtables that, you know, the approach that you adopt where there's been an incident towards the regulators, towards families, towards injured parties, at the start, you know, has a massive impact at the end. If you're helpful, if you're supportive, that's a good thing at the end of the process. If you're not, it will be massively detrimental. So that's always our approach in these incidents. So in terms of the enforcement action available to HSE, again, hopefully none of these will be particularly new to people. There are a number of enforcement tools that they have available to them. Right at the bottom end is providing information and advice. As Elliot said, that's part of their role. They're not just there to prosecute, they're not just there to investigate, they're there to help and support. And often they do this even after prosecution, and it can seem counterintuitive to then pick up the phone to the organisation or indeed the inspector who's prosecuted you. But often they're there to help, and having that help and support afterwards can be really good and helps build that relationship. Serving notices in terms of enforcement notices, you know, exactly as it sounds, you've got to do this, get this done by this time. And I'll come on to this a little bit later. Withdrawing approvals for certain types of work or operations, varying licenses. Issuing a simple caution, we've seen more of this recently, whereby it's not necessarily the HSE's view that a prosecution would help, but they need to be seen to be doing something. The business needs to be put on notice, so issuing a caution in terms of that, and then obviously prosecution, which is their most serious tool available to them in terms of this area. And then that involves a criminal trial. People sometimes forget that HSE incidents are dealt with through the criminal courts, either finding yourself in the magistrates or the Crown Court, depending on the seriousness. One thing I wanted to mention in a little bit more detail, and probably one of the most controversial areas in recent years in terms of the Health and Safety Executive, is fees for intervention. Effectively, this was brought in a few years ago, whereby you had a situation where there had been a breach, HSE would come in and investigate, and now what happens is the business will be charged for HSE time, which is known as a fee for intervention. It has to be a material breach. It can't just be, it can't be a breach at the lower end. It has to be material, and it has to be serious enough whereby the inspector, considers it serious enough to notify the business in writing. The amount of fees that can be recovered, I think I'm still right, it is £166 per hour.
Just increased it.
Per hour. Started off at 140, was it 140? But then £166 per hour. Effectively, what they do is they sit down, they work out how many hours they spent on it, and then they charge the business. what happens is sometimes we will have clients who get more annoyed about that than anything else because they've gone through the investigation process. They're not going to be prosecuted, but then they're slapped with a bill. There are bases in terms of challenging the levels of the fees for intervention, and this is something that we do sometimes. There are discussions to be had with HSE in terms of these, but I still think it's a relatively controversial area. I understand why HSE do it. I get it, but it can be difficult for businesses to swallow, especially, you know, they sort of say, well, why don't you just prosecute me and then get your costs? It's trying to get that across that, look, you've got this, you know, let's go with this. If we need to challenge it, we will, but, you know, let's not go down the road of you know, looking at why didn't you prosecute, because this is obviously a better scenario.
I think why it's so difficult as well is that why it's so difficult to swallow for clients is because any other investigative agency doesn't do this. It's the HSE that does this. If you're being investigated by the police and the police then no further action you or pass your files to the CPS to prosecute you, you're not then landed with a bill for the investigation time. So I think it's very unpopular, as Andrew says, with clients, but you can appeal it. There's a two-stage process for appealing it. If you appeal it on the first stage and it's not successful, you can appeal it again at stage 2, where an independent body away from the HSE looks at your complaint. So there is ways to challenge.
Moving on to improvement notices, which are probably the most common regulatory action that the HSE takes. Effectively, they've been on site, they've done their investigation, or they've been on site for the day, and they know there's a problem. You know, for example, the latest one we dealt with was in terms of guarding for some machinery that wasn't in place, and the HSE issued an improvement notice that it needs to be rectified within a period of time. There are rules and guidance in terms of when improvement notices can be issued. They can also be challenged as well. Most of the time, though, what I would say is that the improvement notices are issued for breaches that need to be dealt with.
Yeah.
You know, there are the odd occasion when we have challenged them and been successful. Most of the time, it is the business will say, yeah, okay, we understand that, we get that. It gives the business, the improvement notice will give the business a period of time to get it rectified, usually as a minimum 21 days. That can vary, depends on the rectification. It may also state that you're not, well, generally it would say you're not allowed to conduct that activity or run that piece of equipment or whatever it happens to be until it's been rectified. But what I would say, and this is where we often come across businesses who have problems in terms of improvement notices, don't ignore them. Make sure there is a policy and a process for the improvement notices being dealt with within the business, and they're not just sat on somebody's desk and they get ignored, and then you face the real possibility of prosecution. Make sure that there are, like I say, the process in place, that they're escalated and they end up with the person that they need to, so they are dealt with. Moving on, prohibition notices. Again, sort of a bit of a crossover in terms of the improvement notice. Again, prohibition notice stopping a risky activity, and it has to set out in detail what the inspector believes the risk is and why there is a risk to that, and that can often lead to discussions between clients, organisations, us, and HSE in terms of that, and the inspector, because sometimes it may not be obvious, and sometimes it can lead to a dialogue, and most of the time those dialogues are helpful, and the positions is explained by the inspector, sort of saying, look, I think this activity is risky because of these points, and it gives the business the opportunity to say, well, actually, our view is, and maybe providing some more information in terms of those. As I say, the activity has to stop immediately until the risk has been remedied and the prohibition notice lifted. Failure to comply is a criminal offence. Again, going back to what I was saying with regards to improvement notices, please don't let them just sit there. Please make sure they are escalated within the business and are dealt with by the person or persons or team who should be dealing with it. Unlike improvement notices, there's no need to identify a contravention of regulations. It's just, you know, there is a risk here, there is a problem here. These are the reasons, like I said, and this is why we need to put this in place. They should, improvement notices, prohibition notices, sometimes not given seriousness by organisations that they should be. If they're not, if they're forgotten about, then it does lead to further action in terms of dealing with this. As I said, there are times when both improvement and prohibition notices are appealed. This has to be done within 21 days of receipt, so it's important, like I say, and I go over this, but it is really important that whoever's dealing with it deals with it in a timely manner. It's appealed to the employment tribunal. Why it's still appealed to the employment tribunal, I have no idea. I know historically why it was done that way, but there is, you're sort of dealing with a split regime really, whereby parts of health and safety enforcement are dealt with through the criminal courts, and then you've got this that's dealt with for some reason through the employment tribunal. I don't think it helps. I think it muddies the waters, and it also means that you're dealing with another tribunal that has different ways of interacting. If the appeal is successful, then the notice is overturned, or alternatively, what we see is that the notice is varied, but more importantly, with the difference between the improvement notice and prohibition notice, until the prohibition notice has been dealt with through the appeal and the appeal has been successful, still in place. You still can't do that activity. You still can't use that piece of kit or whatever it happens to be, and that often forgets. That often is forgotten. Like I say, it's important to have a good dialogue with HSE in terms of improvement notices or prohibition notices, because if it's something that can be rectified relatively quickly or dealt with through better comms or better policies or better procedures, the business is much better spending its money and its time and its resources dealing with that in consultation with the HSE than spending money on people like us in terms of trying to appeal it or having outside help to come in. Getting the problem solved and getting HSE comfortable is a much more cost-effective process. Going to move on to the most serious of the tools that are at HSE's disposal in terms of prosecution, and Elliot's going to help with that.
Thank you very much. But before I do, just one point on appealing improvement and prohibition notices. I think, as Andrew said, it's important that you have policy in place and a procedure in place if you are in the receipt of an improvement or prohibition notice. What I would say is, if you are seeking to appeal an improvement or a prohibition notice, it is important at that point, or at an earlier stage, to take legal advice. The employment tribunal procedural rules can be quite fiddly. We have experience of clients coming to us where they want to appeal, but the 21 days is exhausted because of fiddly procedural rules. Also, lawyers, in my experience, know what to say in an appeal as opposed to a lay client, and we can translate it into the appropriate terminology. So definitely do, if you are seeking to appeal, do take legal advice. So moving on to prosecution, the most draconian tool in the HSE's arsenal. As I said from the outset, the HSE is not an investigator that just seeks to prosecute. They have a number of enforcement methods available to them, as we've outlined in this presentation, but they do critically have the power to prosecute companies and individuals for breach of health and safety laws or failing to comply with prohibition or improvement notices. I won't talk about this too much because we'll be talking about this next time, but in order to prosecute, there are 2 tests that have to be met, and this is taken from the full code test for Crown prosecutors, which the HSE also used. The first is there has to be sufficient evidence to provide a realistic prospect of conviction, and that evidence can be gathered by, as I said before, interviews under caution, Section 20 notices, and other investigatory tools that HSE have at their disposal. The second test, which is very prominent and which we'll be talking about further next time, is that the prosecution must be in the public interest. So it is not enough that the HSE have a slam dunk case. If there is no public interest in prosecuting the offence, maybe, for example, it's very minor contravention, then they must not prosecute and they must look at other enforcement action. In terms of what they consider as part of the public interest, that is, it's a non-exhaustive list, but it's the gravity of the alleged offence, repeat offending if the company keeps offending under the Health and Safety at Work Act or other subordinate regulation. Obstruction of investigations is normally a trigger for a prosecution, or disregarding warnings and notices. And as Andrew said, that's why it's critically important to have lawyers on hand to advise you in an investigation and in an event of an improvement or prohibition notice. Now, a conviction can result in substantial fines or even imprisonment. 2 points on that. The first is that imprisonment is available for individuals, although in health and safety offences, it's normally quite rare. If there are imprisonment, it will be normally a suspended sentence. Substantial fines, though, are the thing that worries companies and corporates. So this is the only available sentence for a body corporate. And the fines can be very, very substantial indeed. So they are normally linked to turnover. And recently, to give you an idea of very large health and safety fines, a train freight operator was fined £6.5 million for breaching the Health and Safety at Work Act following a fatality on one of their sites. So that is prosecution in a nutshell. Just to talk briefly about our next roundtable series. So we have one on the 5th of September 2023. This is preparing for trial. So this is talking a lot about what I've talked about in the previous slide, but in a lot more detail, and taking you through what happens from when a summons is served all the way up to sentencing. So I hope you can join us for that, and that is our final event before the mock trial.
Yeah, as Elliot said, the event on the 5th of September is looking at the preparation for trial, and how we get involved, how we get the parties involved, how the HSE approach the whole process, and how we sort of work with the client team in terms of developing the best way forward in terms of protecting the business, protecting individuals within the business, and adopting that approach. What I would say is it'd be great to see as many of you there as possible for the 5th of September event, and then, like I say, that will follow into our face-to-face event on the 5th of October. Which we're very much looking forward to. We finished slightly earlier than anticipated. If anyone's got any questions, more than happy to deal with them now. If they want to drop into the question interactive part of the programme, that drop them in, can deal with them now. Alternatively, most of you will have our contact details. More than happy to deal with them. If you drop us an email, we will be sending out the slides, so everyone will have a copy of these. And like I say, our next event will be on the 5th of September. But for the time being, thank you ever so much for joining us. Thank you again to the wider health and safety team who spend a lot of time in terms of putting these together and slides together, which is always appreciated. And look forward to speaking to you all again in a couple of months' time. Thank you.
Thank you.